With that, let's give Sandy Steele a warm West Virginia welcome.
Well, I'm not usually compared to James Bond or Ewan McGregor, but I'll take it. Okay, well, thanks very much to the Dean and to Professor Olafaso for that very kind introduction. It's a real privilege to be here and a real honor to give the Baker Lecture this year. So my topic is, the question I want to explore is really this. So do legal systems which do not contain private law, and I'll explain in a moment, by private law I simply mean tort law, contract law, and a law of property, does it fail to respect the moral rights of subjects of the legal system? So I'm going to begin with a few preliminary remarks about the nature of this question and why I'm asking this question. So in the catchier terms of my title, the question could be boiled down to, is there a right to private law? Is there a moral right to private law? So this is really a question of legal philosophy. And within legal philosophy, it could be described as a question of private law theory. It could even be described reasonably as a question of political philosophy. And within legal philosophy, it's a question of normative legal philosophy. So I'm not interested today in whether any particular jurisdiction recognizes a right to private law within its positive law or within its constitution. The question I'm asking is, in principle, should we say that individuals enjoy a moral right whenever they live under a legal system, that legal system contains the rules that we would classify as private law rules? This is actually a question which in recent times in private law theory hasn't received a great deal of attention. So as one prominent philosopher of tort law, Benjamin Sapersky, a US philosopher at Wadham, has written, "The most cogent philosophical theories of tort law have been offered as internal accounts of the practice, and most of them, my own included, have been particularly tied to the nature of the common law. Indeed, I, like many, have disclaimed first-order normative pretensions. I have not said that this system, on its substantive merits, is the best justified system." So a lot of existing theories of tort, contract, and property law, not all of them, are primarily sort of interpretations of existing legal practice in terms of abstract normative principles, but they don't aim to show that we've got a right to live under these types of legal regulation. So why ask this question? Well, I think there are two main reasons why I'm asking this question. The first one is that it gives us a way of thinking morally about situations in which private law regulation of certain spheres of our lives has been cut back in certain ways. So in New Zealand, if you're in New Zealand and you are negligently injured in an accident, you have no entitlement to sue the person who wrongfully injured you. Okay, that's not that your right to sue the person who wrongfully injured you has been abrogated by statute. Your only entitlement is to claim compensation from an accident compensation scheme. Okay, so you've got no civil recourse against the wrongdoer. Now, if you have a right to live under a system of private law, and that right includes a right to enforcement rights against people who've wrongfully interfered with your bodily integrity, then it calls for a substantial moral justification why the New Zealand's type of system calls for substantial moral justification. But the second reason is just I think it's intrinsically interesting to ask whether a justified legal system actually requires a system of private law. So should we think that, morally speaking, living under a morally legitimate legal system actually requires us to have these types of rule? Okay, so here's the overall structure of the lecture and the argument that I'm going to make. So in the first part, I'm going to be a bit more precise about what I mean by private law and get into a bit of the details about what I mean by tort, contract, and property law. Then in the second part, I'm going to examine two arguments as to why there's a duty to establish a duty upon legal systems to establish these types of rule. The first argument is the fairness argument. It's quite an ancient argument, really. In essence, it says that legal systems take away certain rights that you have in the state of nature, in a situation where no legal system exists, and in return for taking away those rights which you had the state not existed, it has to give you something in return, and the thing it has to give you in return on this argument is something like private law. So that's the fairness argument in a nutshell. The second type of argument is that legal systems have a duty to protect moral rights that you have independently of the legal system, and that in discharging that duty, it will have to establish a system of private law. And I'm going to explain some of the nuances of what we mean by protection of rights. But ultimately, to spoil the anticipation, I'm going to say, yes, there is a right to private law, and that these arguments are successful. So I'm going to argue that in favor of these arguments, that there is indeed a duty to establish private law, and that versions of these arguments are successful. Then the final part of the lecture, I'm going to briefly examine whether these arguments also establish that we have a right to private law. So the conclusion of these two arguments will be that there's duties to establish private law. And then the final part, I'm going to examine whether those duties correlate with rights that we have. So whether we can make the move from duties to rights. I'm going to argue that we can. Okay, so what is private law? So this is some sort of basic stuff. So as I'm going to define it, it's going to just be tort law, contract law, and property law. That might seem like it's an overly short list. So normally a conventional list of what constitutes private law would include things like the law of restitution or law of unjust enrichment, the law of trust, the law of company law, family law. So what's the justification for me shortening the list to just tort, contract, and property law? Well, I think it's fair to say that these areas have a centrality to our concept of private law, and that we'd have a serious reluctance to describe a legal system which didn't have these three things as having a system of private law. But if we had a legal system which didn't have a law of trusts, then I think we could, as long as it had tort, contract, and property law, we'd still be willing to say that it contained a system of private law. So if that's true, I think we can say that these three areas have a kind of centrality to the concept of private law. One explanation of that is that these other areas like unjust enrichment, trust, and company law have a kind of parasitic character. These are areas of law which only exist by virtue of the existence of tort, contract, and property law. They're sort of parasitic upon the existence of these areas. So tort, contract, and property law have a kind of fundamental character. If you don't like my definition of private law, you can just rename the title of my lecture A Right to Tort, Contract, and Property Law, okay? If you really don't like it. Okay, it's going to be helpful for the argument that follows to become a bit clearer about the nature of these areas of law. And I think it's going to be helpful in order to do that to distinguish between three different kinds of legal right. So the first type of legal right is a primary legal claim right. So if I have a claim right against you, if you owe a legal duty to me, okay, that's what I understand by a claim right. A primary legal claim right is a right that I have that you do or not do something which is owed to me, which doesn't arise out of the breach of any other duty which you owe to me. Okay, so the right that I have against all of you right now, that you don't punch me in the face without my consent, that's a primary legal claim right that I have against all of you. A secondary legal claim right is a right which I have against you which arises out of the breach of one of my primary rights. So if you do punch me in the face, I will then have a secondary right to gain compensation from you. And that right that I have against you arises out of the breach of the primary right. A legal enforcement right is really a hodgepodge of a number of different sets of rights. So by legal enforcement right, I'm going to be referring to one of three things. So firstly, it could refer to a power to waive a primary right. So if I give you consent to punch me in the face, I'd be waiving your duty not to punch me in the face. That would be an example of a power to waive. A second enforcement right would be a power to trigger a court order. So the power to go to court, sue, trigger a duty upon the court to issue an order to do or not to do something would be an example of a second kind of enforcement right. A third enforcement right is a liberty to secure the benefit of a primary or secondary right. So suppose you owe me a debt of $1,000, I might be able to get permission to go onto your land under certain circumstances and take some of your goods, seize some of your goods, and sell them to satisfy that debt. So that would be an example of the third type of enforcement right. It's a permission or a liberty to do something which would normally violate someone else's rights in order to secure the benefit of one of my primary or secondary rights. Okay. Now, with these distinctions in mind, I think we can get a bit of a clearer sense about what these areas are. So tort law is really constituted in major part by primary legal rights and secondary legal rights, which generally speaking, and this is slightly rough, don't arise from any undertakings. So they don't arise from any kind of voluntary undertaking. So the right that I have against you, that you don't punch me in the face, doesn't arise out of any agreement or any kind of undertaking that we've given to me. Property law is partly overlapping category with tort law. So it's also constituted in part by primary legal rights, like rights that you don't interfere in certain ways with certain objects that I have. And secondary legal rights, like rights to give me back certain objects once you've taken them away without my consent. But it also consists of power conferring rules, like rules of transfer, acquisition of ownership, or transfer of ownership, or transfer of other types of property right. Contract, so as I understand it, this is an area which is constituted by rules which define when an undertaking gives rise to a primary legal right, a legal right to performance of the undertaking, and secondary legal rights like compensation for the failure to perform the primary legal right which is created by the undertaking. Now, a slightly more controversial question is whether for private law to exist, we have to have some of the enforcement rights that I was talking about. So would we describe a legal system which just had the set of primary legal rights and duties but had no enforcement provisions, no enforcement rights? Would we say that that type of system amounted to a system of private law? So a way of thinking about this question is to think about the New Zealand system. So New Zealand hasn't abolished all of its enforcement rights in relation to private law. It's just a very narrow abrogation of the right to sue in relation to your bodily integrity when it's been interfered with through negligent conduct in certain types of situations. So this piece of legislation, the 1972 Act, has now been updated by other legislation, but it essentially is the piece of legislation which initially removed your right to sue for personal injury in New Zealand. But the effect of this legislation is not to remove the primary rights and duties in tort law. Okay, it just removes your procedural rights, your enforcement right to enforce those primary and secondary legal rights. So it maintains the duty in law not to negligently injure a person. That duty still exists in New Zealand law. It's just the enforcement provisions of the duty which have been abrogated. So the legislation makes this clear by saying that you just can't bring proceedings in respect of the violation of one of your primary rights. But the right continues to exist, it just can't be enforced. So would we say that New Zealand, in respect of this particular area where it's taken away your right to sue, does it no longer really have private law regulation there? Would we say that? Well, I'm not going to answer that question. I'm not going to offer a view on whether we need enforcement rights. And the reason why is because the arguments that I'm going to offer are going to be arguments which will hopefully establish a duty to establish private law, regardless of whether we include enforcement rights within the concept of private law. So if you think private law, in order to be private law, has to have enforcement rights, then my arguments will apply to that conception of private law. But if you think that we can have private law even if we don't need enforcement rights, then the arguments will also apply to that conception. So I don't need to decide upon this issue of whether we need to have enforcement rights in order to say that the legal system contains private law. Okay, so let's turn to these arguments then for a duty to establish private law. So this first argument, the fairness argument as I'm calling it, really stretches back to the philosophy of John Locke. But it's gone through a sort of recent reincarnation in the works of people like Benjamin Sapersky and John Goldberg, who often write together, Goldberg and Sapersky, on torts. So these are both US scholars. So here's a version of the argument which Sikorsky gave in 1998, one of his earliest pieces. So he says, where there's a right, there's a remedy, expresses the widely shared conviction that if one has been wronged, one ought, in fairness, to have some recourse through the state against the wrongdoer. In other words, where the state forbids private vengeful retribution, fairness demands that an opportunity for redress be provided by the state. So in return for stopping you from going around taking revenge, the law needs to give you something in return, and it needs to give you some kind of private law recourse in return. Okay. So I think there are, in relation to this formulation of the argument, there's some reasonably straightforward problems that we can identify with this argument. And so these problems have already been pointed out. So one problem, which is neatly stated by Arthur Ripstein in his book Private Wrongs, is essentially that you only have a duty of fairness to give something back to someone if they had an entitlement to that thing. So fairness requires those who prohibit others from doing something to provide a substitute only if those others were entitled to do the prohibited thing. The state does not owe would-be murderers, thieves, and vandals compensation for restricting them. So in the state of nature, you don't have a right to go around, chopping off people's legs because they've wronged you. You don't have a right to take private, vengeful retribution against another person. So when the state takes this away from you, the ability to take revenge on another person, it's not taking away something which you have a moral entitlement to. So if fairness only requires you to give something back when the person has a moral entitlement to it, then fairness doesn't require the state to give you anything here, because taking away your ability to take revenge on someone isn't something which you have a moral entitlement to do. It's not nice to take revenge. Even if you're into revenge, even if you're a fan of revenge, even if you're hot on revenge, it seems unlikely, so this is a second objection, it seems unlikely that most private law legal wrongs are revenge worthy. So most breaches of contract are just innocent, morally non-culpable breaches. So it seems unlikely that even if you thought that that some wrongs were revenge worthy, most of the stuff that we currently recognize in private law wouldn't be revenge worthy. Okay, but what I want to do is offer a revised version of this argument, which actually draws and has some echoes upon later formulations of the argument by Ben Sikorsky himself. So the revised argument is that individuals have moral enforcement rights in relation to their secondary rights in the state of nature. So this is in this hypothetical where we don't live in a legal system. So that's what I mean by the state of nature, in the world where pre this hypothetical where we don't have the state, we don't have a legal system. And if the legal system limits these enforcement rights, it incurs a duty to provide a substitute, and the appropriate substitute for limitation on an enforcement right against the wrongdoer is another enforcement right against the wrongdoer. So let me just explain the first premise of this argument. So, to my mind, if you're wronged, if I negligently damage your leg or I damage your body in some way, morally speaking, in some situations, I'm going to owe you some compensation. Okay, so if I've wronged you, most people are willing to accept that I then have some sort of moral duty to make up for it in some way. So that secondary moral duty which arises out of the breach of moral duties is what I'm calling a secondary right. So it's when you've got a right that arises out of the breach of one of your other rights. But not only that, you also have some moral enforcement rights. So even independently of the state, you have some rights to enforce your rights, morally speaking. So the most obvious example is self-defense. So self-defense is a moral permission to enforce your rights in some circumstances. It's a way of enforcing your rights by preventing the violation of your rights. That's what the core case of self-defense is. And most people think that sometimes self-defense is morally permissible. But it also seems true that you have some moral permissions to enforce some of your secondary rights. So suppose that in the state of nature where there's no legal system, you damage my body in some way and I need medical treatment and it's going to be costly. And the only way I can secure performance of your secondary obligation to pay me compensation so that I can get this medical treatment is by seizing some of your goods forcibly and selling them. so that I can then get this medical treatment, let's say. It seems to me that in some cases that's going to be permissible. So sometimes it's going to be permissible forcibly to enforce your secondary rights, your rights to compensation, and so on. The second premise of the argument is that if the state limits your ability to forcibly enforce your secondary rights, like rights to compensation, it's going to have to give you something in return. And so because it's taken away a right to enforce your secondary rights against a wrongdoer, what it has to give you in return is some other way of enforcing your rights against the wrongdoer. And then that's beginning to look a lot like private law. It's going to have to give you some avenue of recourse against the wrongdoer. So let me just elaborate a bit more on each of these premises. So why believe that individuals have this moral permission to enforce their secondary rights, their rights to obtain compensation in the state of nature? Why believe that you're entitled to exercise force in order to get compensation from someone? Well, I think there's a reasonably strong analogy, actually, in some cases between self-defense, acting in self-defense, and acting forcibly to obtain compensation. This analogy was actually first suggested by this chappie here, Christian Thomasius, who was a German lawyer in the late 17th, early 18th century. And he suggested, he drew an analogy between rights of self-defense and rights to obtain compensation. So when you act in self-defense, you act in a way to prevent harm to your rights. So it's self-defense, in the core case, is harm preventative. When you act in order to obtain compensation, we could also think of that as something quite close to harm prevention. So it doesn't directly prevent the harm to your rights occurring, but it's restorative. It removes the harm which occurred to your rights by trying to undo the harm which occurred. So there's a relatively close connection between rights to act in self-defense and rights to act in compensation, insofar as compensation is genuinely restorative. So if it's sometimes morally permissible to act forcibly to prevent violations of your rights, it's also plausible, given the similarity between defense and obtaining compensation, that you can sometimes act forcibly to enforce your secondary rights, your rights to obtain compensation. Okay. Why does the legal system, though, incur a duty to provide a substitute? Because you might argue that when the law prohibits you using force to satisfy duties of compensation that other people owe to you, it's not actually taking away any moral right that you have. So morally speaking, we might say you're still perfectly permitted to go around using force. If that's just a moral fact, that it's morally permissible for you to use force to satisfy these secondary rights that you have, then the law doesn't take that away from you. It just makes it more difficult. You know, if the law says that if you forcibly try to obtain compensation from someone, you'll go to jail or something like that. It doesn't prevent you as such from doing that. It just makes it a lot more difficult, because now you've got the threat of being punished if you go around to my house and take some of my goods and sell them just forcibly without any legal authority. But even although the legal system might not take away your moral right to forcibly obtain compensation, it makes it a lot more difficult to exercise that moral right. So consider a really simplistic analogy. Imagine that someone's attacking you, and you need a rock which is just sitting nearby, to bash the wrongdoer, okay, in order to stop the wrongdoer from attacking you. I know this fact. I know that you need the rock to stop the wrongdoer from attacking you. Given that I know those facts, it seems plausible that I've got some kind of moral duty not to prevent you from obtaining access to that rock, if that's the only way you have to defend your rights at that time. Now, so if that's true so if I have some moral duties not to interfere with your defensive rights, then given what I've been saying about the analogy between self-defense and compensation, we might also say I've got some moral duties not to interfere with your ability to exercise your compensatory rights, your ability to obtain compensation. So if I take your football and I have a duty to give it back, and the only way you can get it back is by coming onto my land and taking the football back, we might say I've got a duty not to build a gigantic wall preventing you from exercising this secondary right. So I haven't removed your moral right to the football, but I've made it much more difficult for you to exercise that right. So when the state says, if you forcibly exercise your rights to obtain compensation by seizing someone's goods or seizing their assets without permission, if it says, if you do that, you will be punished, it's like the state is building that wall which is preventing you from exercising your rights. It's making it a lot more difficult for you to exercise your rights, because now you've got this threat that if you forcibly exercise your rights, you go to jail or something like that. So it's analogous to placing a barrier to the exercise of your rights. So I think the legal system incurs a duty to provide a substitute, not because it's deprived you of the moral right itself, but because it's made it substantially more difficult for you to exercise your moral right. And in return for that, it's got to provide you with some mechanism by which you can now enforce your rights. And that's where private law comes in. Okay, so I hope I've made that at least reasonably plausible. But there are some objections we might raise to this revised fairness argument that I've offered, which draws upon the removal or the interference with moral enforcement rights. So there's the kind of New Zealand objection. Why does the legal system come under a duty to provide a civil enforcement right, so a power to sue the other person, rather than something like what happens in New Zealand, like a compensation scheme? So when the state deprives you of your ability to obtain compensation from the wrongdoer, couldn't it satisfy its duty under the fairness argument simply by setting up a compensation scheme which entitles you to compensation from a state fund? Wouldn't that be just as good a way of satisfying its duty? Well, I think I have three responses to that objection. First of all, the closest substitute to depriving you of an enforcement right or making it more difficult to exercise an enforcement right against the wrongdoer is to provide you with another enforcement right against the wrongdoer, not against someone else. Okay, so in New Zealand, what happens is that you have a right against a state fund, but your initial right was a right against the wrongdoer. So the closest substitute to what's been taken away from you would be to provide you with a right against the wrongdoer, the person who wrongfully injured you, rather than against a compensation scheme. A second response would be that some harms are potentially only reparable through the provision of an action against the wrongdoer. So sometimes when you're wronged, but particularly with certain forms of culpable wrongdoing, it can have a tendency to sort of undermine your sense of self-esteem or your sense of self-respect. So if someone wrongs you and they don't acknowledge that wrong in any way, then it can be quite damaging for your well-being, just because it undermines your sense of self-worth, I suppose. And it may be that type of harm is only reparable if you're provided with some kind of means of acting against the wrongdoer, himself or herself, and extracting a compensatory duty, the satisfaction of a compensatory duty against the wrongdoer. That's perhaps potentially the only way of undoing that sort of moral harm which has occurred through the wrong. So you might say that the criminal law can do that. We don't need private law to get involved in that type of situation. So culpable wrongdoing, we might say that's the business of the criminal law, and the criminal law can undo these kinds of expressive harm which occur with certain forms of wrongdoing. But I don't think that's going to be quite enough. So there are some wrongs which it's not appropriate to criminalize, but which are still quite serious attacks upon a person's self-worth, potentially. So they could still be, some forms of negligent wrongdoing we might think are not appropriate subjects of criminalization, but they could still have a serious impact upon someone's sense of self-worth. And perhaps that makes it more appropriate to provide a civil action rather than to leave the remedying of those kinds of expressive harm to the criminal law. A third argument is a more practical argument that it's just not realistic to replace private law in cost terms across the board with a compensation scheme. So imagine for every breach of contract, you had an entitlement against a state fund to claim compensation for the breach of contract. That's just not a feasible system. So it may be that in return for taking away some of your enforcement rights in the state of nature, just as a matter of real-life practicality, the state has to provide private law just because it's a cheaper option, rather than because of any deeper principled reason. A second objection is that if you're so weak and poor that you would have been unable to enforce your rights in the state of nature, well, you've not actually suffered any loss when the state prohibits your enforcement rights once we have a state. So when the state prohibits you from exercising your enforcement rights, you might not have lost anything because you might have been so weak and poor that you'd been unable to force the wrongdoer to pay you in the state of nature. So can't the legal system say, well, you've suffered no loss here. You're not any worse off because we prohibited your enforcement rights, because you wouldn't have been able to exercise those enforcement rights anyway. Well, I think I've got two responses to that objection. The first response is that in most cases it's just going to be impossible to say whether in the state of nature you would have been able to exercise your enforcement rights. It's just going to be impossible to know whether you would have been able to exercise your enforcement rights. So we can, in virtually all cases, we're going to be able to say that there was a chance, you had a substantial chance of being able to exercise your enforcement rights in the state of nature, and that the state has a duty to compensate you for the loss of that chance of being able to exercise your enforcement rights. And in order to give you compensation for that chance, it needs to provide you with the power to sue, which gives you an opportunity to enforce your rights. So for depriving you of a chance of enforcing your rights, the state gives you a chance of enforcing your rights through private law. But there will be some cases, I think, where it's going to be potentially reasonably clear that you haven't lost anything, and the argument just doesn't apply there. So in some cases, it is going to be true that you haven't suffered any loss. But here I would say that for most people, it's going to be true that you have lost something by this prohibition on private enforcement of your rights. And so that gives the legal system an obligation to set up something like private law. And then the private law could then say, well, we're going to exclude the really poor and weak from the ability to enforce their rights. But that doesn't look right. So it seems like there then would be another type of fairness duty which would arise once you have private law up and running, to not discriminate between people in the access to private law. So there might then be a further duty which would arise once you have private law up and established, to ensure that we don't have discriminatory access to private law. But that's external to this argument. That would be another type of duty which would then arise once you have the institution of private law up and running. Finally, you might worry that Ripstein's objection kicks into my revised argument as well. So remember, Ripstein's objection was that when the state takes away your right to vengeance, your ability to take vengeance against someone, it's not taking away anything you had a moral right to. Well, you might say, you don't actually have a right in the state of nature to go around grabbing people's goods in order to satisfy the compensatory obligations they owe you. You might say that's morally wrong. You shouldn't be going around doing that. Perhaps what you should instead be doing is you should be getting on with the project of forming the state and forming the legal system and trying to establish an orderly system for the enforcement of rights. So rather than going around just grabbing people's goods or grabbing their assets in order to satisfy obligations they owe you, you should be trying to establish a state. You should be entering into the civil condition, as some philosophers put it. But I think in many cases that's just not going to be realistic. It takes more than one person to set up the civil condition, to set up the legal system. And if they're not cooperating, then your only option is to forcibly enforce your rights. So I think you do have an entitlement under those conditions to forcibly enforce your secondary rights in the state of nature. Okay, that's enough on the fairness argument. I'm sure you're all convinced already. So moving on for the second type of argument. So this is the argument that the legal system has a duty to establish private law because it has a duty to protect moral rights which exist independently of the legal system. So we all have, hopefully it's going to be uncontroversial, that we've all got moral rights in relation to our bodies, okay? So that morally, you ought not to use my body without my consent in certain ways. Morally, you ought not to negligently damage my body in certain ways. And given these moral rights which exist independently of the state, we've got some sort of duty to protect these rights through private law. So in order to assess this argument, I think we need to get a better sense of what we mean by protection of rights. So I think there's at least 3 different ways in which the law can protect rights. So the first way is that it may just authoritatively determine the content of a right, of a moral right. So what I mean by this is simply that the law might reflect the content of what your moral right is. So suppose that when you're having a serious surgical operation, a doctor has a moral duty to inform you of the risks of that operation, or some of the risks. The law might protect that right by simply establishing a legal duty upon doctors to inform you of certain risks when you're having an operation. It might just replicate the content of the moral duty that doctors have in that situation. That would be one way in which the law could protect your moral rights, just by replicating the content of those moral rights. A second way it could protect your rights, perhaps more obvious way, is by providing incentives against their violation, by providing, say, sanctions or enforcement proceedings in order to incentivize people not to violate rights. A third way is that it might just secure the benefits of your primary or secondary rights through remedial enforcement. So even if no one's listening to the law, even if no one is incentivized to respect your rights because of the existence of law, we might still think there's good reasons for the law to just force people sometimes to respect your rights. So if you owe me $10,000 in compensation, an example of this third type of protection would be that the law sends the bailiffs round to your house and seizes your goods in the value of $10,000. That might not incentivize anyone. It might not incentivize anyone not to violate rights in the first place. But it's another way of protecting rights, which is independent of whether it provides any kind of incentives. Okay, so what I'm going to argue is that at least in relation to 1 and 2, that there's a duty to do these types of protection through private law. I'm less actually sure about 3. I think probably 3 is true as well. But I'm going to make the argument by reference to bodily rights. Okay, so I'm going to start off with uncontroversial moral bodily rights, and then briefly and too sketchily try to extend the argument to property rights and contract rights. So I'm going to start off with bodily rights. Okay, so why would there be a duty to reflect the content of primary and secondary moral bodily rights? So these are things like rights that people don't touch your body in certain ways without your consent, or rights that people don't damage your body in certain ways. Well, a simple observation is that simply having a legal duty which replicates the content of a moral duty might actually reduce the number of wrongs in the world. So simply imposing a duty upon doctors which says you have a duty to inform patients of these sorts of risk might just reduce the number of times that people suffer moral wrongs. Why? Well, from the mere fact that something is legally obligatory, some people might just be moved to do it. Okay, so some people are just rule followers. They just think, oh, that's the law, therefore I got to do it. So there might be some people like that, and that's a problematic attitude to have towards the law, but some people might just be moved to do it just because it's legally obligatory. And if the law reflects the genuine moral content of people's rights, then that's great. That's going to reduce the number of moral wrongs in the world. But there might also be other cases where people trust the law as a moral authority upon certain issues. So it may be that in, say, things like food regulation or something like this, that people are genuinely puzzled about what morally they ought to do. And by specifying the content of moral rights, the law might actually reduce the number of moral wrongs in the world. So insofar as the law can specify the content of moral rights which are uncertain in certain ways, that might also reduce the number of moral wrongs that occur. Now, reducing the number of wrongs in the world, that's a nice thing. It's a marvelous thing. But why is there a moral duty to do it? Okay, not everything that's good do we have moral duties to do. Why is there a moral duty to reduce the number of wrongs to people's bodily integrity? Well, I think the reason why there is because each of us has this basic moral duty of easy rescue. So you might be familiar with the sort of classic example that Peter Singer gave in the 1970s. You're walking past a drowning child, you know, in a shallow pool of water. At no cost to yourself, or at minimal cost to yourself, you could rescue the child from the shallow pool of water and save the child's life. Now, most people are content to accept that you've got a moral obligation to do that there. So we have moral obligations to assist people in cases of where there's a serious risk of damage to their fundamental interests when there's a relatively minimal cost to ourselves. Now, simply establishing legal primary rights and duties is not necessarily a hugely costly exercise. So remember, we're not talking here about providing enforcement proceedings. We're just talking about legally declaring that it's wrong to do certain types of conduct. Now, that seems to me to fall within the moral duty of easy rescue. So if it's true that simply by declaring that it's morally wrong, it's legally wrong to do these types of things, we significantly reduce the number of wrongs in the world, and that's at reasonably minimal cost because it doesn't require costly enforcement proceedings, then I think that would come within this moral duty of easy rescue. So this would be a substantial benefit that we could accrue, that we could give to other citizens at relatively minimal cost to each individual. What about a duty to deter? Do we have a duty to deter or to incentivize people not to violate moral bodily rights through private law? Well, this really is partly an empirical question, but let's suppose that providing enforcement proceedings in private law does reduce the number of right violations that occur. So let's assume that law and economics are broadly right, and that providing enforcement proceedings in private law is likely to reduce the number of overall wrongs in the world. Would we have a duty to do it on that basis, that it's going to reduce the number of occasions of wrongdoing? Well, again, I think the easy rescue argument tends to suggest that we would have a duty to. So if it's true that private law regulation of bodily rights is going to add something to the reduction of wrongdoing, a significant reduction in relation to really fundamental interests like bodily integrity, then we have a duty to do it if it's not going to be extremely costly. And the cost to each individual citizen is potentially relatively small. I think there's at least two objections, though, to this type of argument. One is that the sort of classic objection to deterrence arguments in this context, which is maybe more prominent amongst theorists of private law on my side of the Atlantic than it is on this side of the Atlantic, which is that it uses wrongdoers merely as a means. So using you merely as a tool for social deterrence is using you purely as an instrument to help other people, and that's morally problematic. But I think that objection fails in this context so long as wrongdoers are given a reasonable opportunity to avoid becoming legally liable. So long as whether you become legally liable is to a large degree up to you, if you've got a reasonable opportunity to avoid becoming liable to pay compensation and liable to enforcement proceedings, the law's not using you purely as a means there. It's giving you a choice. And it's recognizing your choice in the construction of legal liability rules. If it was treating you merely as a tool, well, tools don't have the ability to choose stuff. The law is treating you as a rational agent with the ability to choose whether you become legally liable. So long as wrongdoers are given a reasonable opportunity to avoid becoming legally liable, I think this objection doesn't hold. A more serious objection is that, well, if we're interested in deterrence, why not go down the route of criminal law or other forms of regulation? Why do we need to do it through private law? Well, this is an objection which would take another lecture to address. But if it's plausible that there are some contexts in which private law regulation is going to add something to the deterrence toolkit, so if it's plausible that the addition of private law forms of regulation is going to substantially reduce the number of wrongs in the world, above and beyond the criminal law or above and beyond other forms of regulation, then I think the argument does go through and we would have a duty to do it. So if it's going to substantially reduce the number of moral wrongs at reasonable cost, then it would fall within this moral duty of easy rescue. Okay, I'm not going to talk about the third argument, actually, because I'm conscious of time. So, moving from bodily rights to property rights and contract rights. So, on one view of property rights, even independently of the legal system, we've all got basic moral rights to property over certain fundamental things. So even independently of the legal system, I think it's reasonably plausible, you might think, that given that some minimal level of property holding is quite fundamental to people's well-being, it's plausible that even independently of a legal system, we've got some moral rights to external goods. If you accept that, then I think the arguments that I've already been mentioning would apply to property rights too. So the duty of easy rescue. So in relation to property which is fundamental to people's well-being, it's plausible to think that the duty of easy rescue argument would kick in there. So insofar as the law can give authoritative guidance on the content of basic moral property rights, insofar as it can deter people from interfering with people's basic moral property rights, that would also seem to fall within the duty of easy rescue that I've been talking about. But I think a further argument arises in relation to property rights. This is an argument which is often mentioned by Kantian scholars of property law. And the argument starts from the observation that if we don't have a legal system and we're trying to enforce our property rights against other people, there's something morally problematic about that, because even if we're morally entitled to have property rights, there are a wide range of systems of property rights which are compatible with our basic right to hold property. So if you think about the rules of acquisition of property, do you acquire property when you take possession of it? Is it when you look at the property? Is it when you sort of scratch your name in the property? There's a number of different rules of acquisition that we could have, and these rules are to some extent conventional, right? They're chosen by as a result of social convention, and they all might be compatible with our basic moral right to hold property. So if I claim to be entitled to property in the state of nature, and I say, well, I've acquired this object because of the rules of acquisition that I believe in, I'm privileging my judgment about what the appropriate rules of acquisition are over your judgment. But there's no basis for my privileging my judgment over your judgment, because remember, the rules are just conventional. They're not part of they're not part of moral reality. There's no moral truth about whether acquisition should require just looking at the property, scratching your name in it, or taking possession of it. So if I'm claiming to be entitled to enforce my property rights in the state of nature, I'm privileging my own personal judgment about what the appropriate rules of acquisition or the appropriate property rules are over your judgment. But your judgment should count equally here, because we're moral equals. So there's no reason for my judgment to be privileged over your judgment in relation to these issues, which are a matter of purely conventional rules. So on the Kantian view, the only way to escape this problem is to set up some kind of public authority which doesn't reflect our individual views. It doesn't reflect just my view about the rules of acquisition or your view about the rules of acquisition. It reflects an omnilateral view about the appropriate rules of acquisition. It doesn't just reflect any private individual's judgment. So there's another argument, I think, which is quite plausible in relation to property rights, that if you want to hold property permissibly, morally permissibly, and you want to be able to enforce your moral property rights, you need to enter into the civil condition. You need to establish legal institutions. Otherwise, you will be privileging your own private judgment over another person's judgment, which is inconsistent with your innate equality with other people. So I think there's a plausible Kantian argument that you have your duty to respect other people's innate equality with you also generates a duty to establish legal institutions. So I think that argument also applies to contract rights. So a lot of contract law is just conventional. Some of you will have studied already things like the postal rule. When does an offer accepted? Is it through when you put the letter in the post? If anyone uses post anymore, these rules are not out there in moral reality. They're partly conventional. So if in the state of nature I insist that an offer is accepted at this particular point in time, I'm just privileging my own private judgment over your private judgment. There's no objective basis for my judgment. These rules have to be set by some independent authority. So, insofar as contract law, or our contract law is at least partly conventional, the rights it's tracking are partly conventional, I think the canteen argument also applies to contract law. I also think the duty of easy rescue argument also applies to contract law. A lot of human well-being is dependent upon the existence of a system which determines when undertakings become binding and when undertakings become enforceable. So that also, I think, could be justified by reference to the easy rescue argument. Okay, I promised at the beginning to move from duties to rights. So far I've just been talking entirely about duties to establish private law, but can we make the move from duties to rights? Now, in truth, if you're happy with the idea that there are duties to provide private law by virtue of these two arguments, I don't think a lot turns upon the question of whether there is also a right to private law. To be honest, I chose that title because it was a lot catchier than the title Duties to Provide Private Law. The right to private law is a catchier title. I don't think a lot of moral significance hinges upon the question about whether these duties, so long as if we accept that the legal system has a duty to provide this system of rules, and that duty is owed to subjects of the legal system, I'm not sure a great deal further turns of moral significance upon whether we say citizens have a moral right to private law. However, I think it is plausible that just linguistically, conceptually, that we would say that these are duties which correlate with rights, at least in some cases. So if we take the fairness argument, remember the fairness argument says that you've been deprived of the ability to exercise one of your rights. Now, on a plausible theory of rights, a right just is, you have a right when an interest of yours is sufficiently important to justify a duty. So that's a famous analysis of rights given by Joseph Raz. So on one plausible view about what a right is, it's just an interest of yours or interest of an entity which is sufficiently important to justify a duty. Well, I think we would say that the duty to provide an enforcement right is justified by an individual's interest in whatever their primary right is. So if it's their bodily integrity, it's their bodily integrity which justifies their primary right, that their bodily integrity isn't interfered with. It justifies their secondary right, and it also justifies their enforcement right. So it's just that basic interest you have in your bodily integrity which justifies all of those sequence of rights. So I think the fairness argument plausibly is an argument which establishes a right to private law on this understanding of rights. The duty of easy rescue argument, which is a way of justifying the duty to protect people's rights, is more complicated. So typically, I think what R.J. Wallace says in his book, The Moral Nexus, is true, that we tend not to think of duties to help people who are in severe distress as correlated with rights that those people have against us. He says, though there are duties that we stand under to help people who are in severe distress, we are reluctant to suppose that any specific individual has a claim against us to such assistance. So even if we owe moral duties of assistance to people in other countries, for example, we might be reluctant to say that they have individual rights against us to that assistance, because we tend to think that duties of assistance, duties to help other people, are kind of discretionary in character, that you can sort of choose when you assist others, and that doesn't really gel with the language of rights. So perhaps the duty of easy rescue argument is less plausibly justified by rights, but certainly on the Razian understanding of a right, we would say that the duties you have to assist other people are grounded in their interests. They're grounded in really important interests that those people have. And so it might not be that implausible to think that, in some sense, those duties are correlated with rights on the part of those individuals, but they might be rights of a special character. The duty to respect the innate equality of other people, I'm not sure your interest in being recognized or in being treated as an equal is necessarily justified by any particular interest of yours, but it's justified by an aspect of your moral status as a free and equal person. So we might expand the Razian definition of rights, I think, plausibly as you have a duty is correlated with a right where an interest of the other person is sufficiently important to justify the duty, or where an aspect of a person's moral status is sufficiently important to justify the duty. And if that's true, we would say that the duty to respect a person's innate equality is correlated with a right on their part to be treated as an equal. And there we go. So I hope to have convinced you that, that there are at least two plausible arguments for a duty to establish private law, and that duty is correlated with a right to private law. So thanks very much for listening.